let me express my extreme disappointment with you. You've now picked up a new case. Is it on docket today or no?
It is, Judge. We placed it on after we spoke.
Mr. Foster, you now stand charged with the offense of assault. You are facing up to a year in jail and or a $4,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. For some reason, I don't see it.
12, Your Honor, it's under Smith.
Well, Judge.
Tristan Smith, I'm sorry. I called you Foster, I meant Smith.
When you, ADI was a 2B, so this is a longer on the new case, the new charge. The previous one, which is the AFM, because he has 2 open misdemeanors right now.
Right, so he initially had the open assault of a family member.
Yes.
As of December 19th, he's now picked up a new assault.
Yes.
All right, let's do probable cause
On the new assault.
on the new one, please.
Yes, Judge. On October 29th, 2024, an officer was assigned to investigate an assault that occurred on the 18th of October at a residence in Harris County, Texas. The officer reviewed video footage of the assault that showed the first complainant and the defendant engage each other in a physical fight until another female assisted the defendant by punching the complainant and grabbing the complainant by her hair. The female swung the first complainant to the ground by her hair, causing pieces of her hair to be ripped off while the defendant punched the first complainant multiple times in the face. As the first complainant was on the ground, the defendant stomped once on the back of the first complainant's head, and the officer observed the first complainant with injuries based on photos. The first complainant told officers that on the day of the offense, the defendant told her that he was going to assault her once she exited her vehicle, and a friend of hers that was inside the vehicle recorded the fight. The defendant and the first complainant used to be friends, and the defendant used to live with the first complainant at her residence until the defendant was kicked out.
Judge, if I can, just utilizing the state's information that they provided, I didn't hear the prosecutor read this part, but at some point the officer interviewed the complaining witness in the new assault. Based on what she told him is that she had heard that Mr. Smith was going to attack her. And if you just read in the DIMS, she exited her vehicle to engage in a physical fight with Mr. Smith to defend herself from him. When I talked to Tristan about this last week, he told me all about it. He said, I remember this because it is a 2B. He hadn't heard nothing, any follow-up on it. This young lady got out of her car and attacked him as he was walking down the street. It says it right here. MB exited her vehicle to engage in a physical fight with Mr. Smith to defend herself from him. She's in a car where she could have easily seen him and kept driving. No, she got out of her car and attacked him exactly like he said. And while he was defending himself against her, another individual, another female came to assist him in this fight because he was attacked and blindsided. This is exactly what the complaining witness in this case told the police happened, except she said that, well, I heard that he was going to attack me, so I jumped out my car and attacked him first. That's not an assault.
I don't know. All I know is that the facts are pretty egregious. And I mean, he could have taken off, didn't have to sit there and didn't have to engage. He could have, you're on bond for a criminal case. So stop. I'm not asking you to say anything. You, in the correct mindset, I have an open assault. It's probably a pretty good idea for me to go away and not do anything here.
And if he had that time to reflect in that instance, then perhaps he should have done that. But he's walking down the street and this girl jumps out the car to engage him in a physical fight, like she told police that she did, to defend herself from him. He doesn't have time to sit and reflect, oh, I got a case and all. He
could have run away. He could have gone. He could do something else. I don't know.
Being attacked, Judge, I mean, you got to do something.
Look, I get that there's always 2 sides to the story. But I mean, I'm going to find there's probable cause now.
I understand.
If you develop something later, if you see something on video, if you show something that she's the initial aggressor, come back and we can talk.
She said it. She told the officer.
I don't know that for sure. I mean, it just,
Let's say in self-defense.
Yeah, we have in self-defense, and then we have furthermore that once the female was assisting the defendant, that the defendant continued to assault the complainant, even stomping the complainant on the head.
Well, you got to stop her if she's attacking him.
Well, Judge, she was down on the ground. The complainant was down on the ground and the defendant stomped on her face.
I'm finding that there's probable cause. You picked up a new case.
And we'll deal with that, Judge. But the biggest issue, of course, is the fact that he did pick up a new case, albeit he didn't ask for it. I mean, he's walking down the street. And his situation being one that's extraordinary, one that I haven't seen much this year, dealing with indigent defendants, being of his age, which is a high school student, as we've talked about before, pending graduation with an acceptance to a great school. This is a very tenuous time for him. You've already ordered him to be drug tested before and all of that. So we're working through those things. The last thing that, and I know we have to consider the complainant witness in the community and all of that. I understand that. But I'm advocating for Mr. Smith.
I get it.
Mr. Smith has a final on Monday that he must take. If he does not take this final, and he's again in high school, then he may not graduate. If he doesn't graduate, then we can kiss Baylor goodbye. It's not likely to happen for him in light of all of the challenges that he's dealing with. He doesn't have his mother to help him. His grandmother, we know she's a complaining witness. He can't even go around the house. He doesn't have any help right now. He's living with a friend and walked here from Atascocita this morning, which took him 9 hours. I mean, this situation it's extremely difficult, Judge. So my ask is that we do something, and it could be amend bond conditions, but to keep him on bond so that he can take his test, do what he needs to do to finish school, and hopefully we can resolve these issues. I've looked at the evidence that the state has submitted for the new case. There's clearly something happened, clearly. I mean, and I would see the evidence shows that. But if he's walking down the street and this girl, per her own admission, jumps out her car to engage into a physical altercation with him to defend herself, that doesn't make sense. And that's not really fair to him. Someone that's on bond, and everybody knows he's on bond because she said, I knew him. We used to be friends.
He could have walked or run away, gone to a store, called the police. There were a multitude of other options you could have done. You know what's at stake here, yet you pick up another case where you allegedly stomp on someone's head. And you want me to let you go? I understand that you have school. I don't know that you have a final on Monday. Am I supposed to take your word for it? No. All I know is that you are a danger to my community. You have one assault. You have had violations on bond while you're on that assault, and now you've picked up another assault. You are a danger to my community. And there's only one thing that I need to do, and that's to put you in jail because you refuse to comply with bond conditions. And I've given you over and over. I appreciate your tenacity, and I love that you're defending zealously, but I can't let him go. It would be enabling this behavior and telling him it's okay for you to do what you're doing. And it's not. It's not okay to sit there and stomp on someone's head.
And Judge, we anticipated that possibility. I'd ask in the alternative that you consider a very low bond, as my client has approximately $100 to his name, being a child, in my mind, a person that hasn't even graduated from high school.
State of Texas, what do you think?
Judge, we would be opposed to that. I mean, given the egregiousness of these facts, we believe the defendant is a.
I won't do the normal. What I normally do is I set bonds at 5,001 when you pick up a new case. I'm willing to go down. I'm not going to give them $100 bond because that's what we do on new cases.
I'd ask
And I
for,
think that that's a little.
so we're going to revoke the previous bond, that was a personal
I will
bond.
only touch the old case.
And so we'd ask that, well, I didn't anticipate that you set a personal bond on the new case. So I guess my request would be 2 $500 bonds.
Oh.
I mean, we're talking about a misdemeanor assault between children, not a.
Well, I don't know that. I mean, you're
Well,
putting
state
in
of-
stuff that I have no
The
idea
state
about.
alleged a misdemeanor assault. They didn't allege an aggravated assault, which they could have, and they did not. They alleged a misdemeanor
Doesn't make me
assault.
feel better.
Well, I mean, the state says, alleges that there's all this injury. We can see what the injuries were. You see the complainant witness in the picture. She's smiling.
Did you go
as
to
she's
the
talking
hospital?
the police. No, she didn't go to the hospital, Judge.
I don't know.
I've read everything. She hasn't gone to the hospital. She has a swollen eye is what she has.
Judge, I don't believe, I mean, her hair was also ripped out, Judge, based on what we see in the four corners of the dims. We haven't
I
done,
don't know. I mean, there's a lot of people who wear different types of hair.
sure.
No.
But just going off the dims, we have her hair being ripped out and being stomped. So
And to your question, not hospitalized, Judge.
So here's what I'll do.
Judge, just if I may add, even in the first AFM, Judge, the complainant has gone back to the home at least once, to my knowledge, based on my communications with the complainants on that case. The defendant has gone back to the grandmother's homes, contrary to the bond conditions and the no contact orders. In that case, he's repeatedly, time and time again, violated his bond conditions, and now so we would be opposed to anything less than $1,000.
Yeah, I know. So what I was going to, his bond on the first assault it's $1,500. I'll do 2501 on that. Okay, I'll only raise it at $1,000. On the new case, what do you think?
1,000.
Should we give him a PR bond?
Judge,
No, Judge.
we'd be opposed based on the nature of the allegations where he stomped on someone's head, pulled her hair, and in addition to that being picked up just a month after the previous AFM.
And charged with a misdemeanor. I mean, if the state felt so vigorously about this case, then they would have filed it in district court. I mean, this is a misdemeanor assault between.
I think there's no way this would have been gone upstairs.
I agree, and which is why I think a personal bond could be adequate in light of the fact that he would be given a surety bond on his previous case. He doesn't have much of anything. If anything, that keeps him in jail until we get to trial, because that would be a case that we would set.
All right, Mr. Brooker, I'll set the new one. I'll set it at $500.
Thank you, Judge.
I hope you get it. You're going in today, but I hope you get it. I mean, we're not going to stand for this. You got to pay the piper. And I don't know if it's dealing with the school now will get you to wake up and realize that you can't do what you're doing, but that's it. I've literally bent over backwards not to put you in jail, Mr. Smith. Literally bent over backwards. How many chances have we, Yeah, goes with you. Okay, Mr. Smith, good luck.